If Elon Musk is in the news, it's usually for one of three reasons. He's announcing a Tesla product that will never materialize, he's revealing the existence of another child, or he's pretending to buy a company and then backing out. Well, Tesla doesn't have any new products, he's up to 10 kids that we know of, so Elon Musk now wants to back out of his purchase of Twitter. Although some headlines said Musk cancels Twitter deal, that's not quite accurate. Musk has informed Twitter that he believes that the company is in breach of the acquisition agreement, and that he therefore will no longer perform the contract by purchasing the company. Twitter, on the other hand, says that it will sue to force Musk to buy the company at the original sales price. So this raises all sorts of questions. Can Elon get out of the deal because of bots? Can Musk pay $1 billion to cancel the contract? And if Twitter sues, can a judge force Musk to go through with this multi-billion-dollar deal? So how did Elon Musk find himself in this situation? Well, Musk is an avid/obsessed Twitter user. In early 2022, Musk initiated conversations with Twitter bigwigs and started buying Twitter stock. In February and March, Musk accumulated over 9% ownership of Twitter's common shares without formally disclosing his interest in a potential purchase, which was a violation of SEC rules. The SEC mandates that anyone who acquires more than 5% of the company's common shares has to disclose those holdings within 10 calendar days. Musk finally signed his filing 21 days after March 14th, the date his stake surpassed 5%. Now, after accepting and then rejecting a seat on Twitter's board of directors, Elon Musk made an offer to purchase Twitter for $44 billion. After a bunch of back and forth, Twitter agreed to sell if Musk could come up with the financing, eventually settling on a purchase price at $54.20 a share, which is entirely possible to be a 420 joke. Now, for reasons I won't go into, Musk styled the deal as a merger with a specially created company. So if you hear the term merger agreement, you can just think of purchase agreement. And on April 25th, Twitter and Musk announced a joint agreement. Quote, "Free speech is the bedrock of a functioning democracy, and Twitter is the digital town square where matters vital to the future of humanity are debated." Musk also said, quote, "I also want to make Twitter better than ever by enhancing the product with new features, making the algorithms open source to increase trust, defeating the spam bots, and authenticating all humans." But on May 15th, Musk started trying to backtrack on the deal. He tweeted that he was putting the deal on hold because he believed that more than 5% of Twitter's user base was made up of bots. A bot in this context means an automated account that isn't linked to a real person. Now, Twitter gave Musk more information about bots, but on July 8th, Musk told the SEC that he was exercising his right to terminate the contract. Twitter fired back that it will sue Musk to have him buy the company. So, can Musk end the contract, or can Twitter sue him for damages? Well, everything hinges on the contractual language that Musk says gives him the right to terminate the deal. So let's look at the letter that Musk sent to the SEC claiming to back out of the deal, and let's look at the contract provisions to see what rights are afforded. Now, mergers and acquisitions transactions often involve the disclosure or transfer of personal data from a seller to a purchaser. This may include all data about the target company and its assets, like data about employees, customers, users, and contractors. Now, one point of clarification here, this is not due diligence. Due diligence is something you do before you enter into a merger or acquisition agreement. But in this case, Musk didn't do very much due diligence. He signed the merger agreement without having access to much inside information from Twitter. Here, Musk says that he is terminating the contract because Twitter violated its obligations to provide him with access to information that is required under the contract. But crucially, this is not information for due diligence purposes. The time for due diligence is long over. It was over the second that Elon Musk signed the merger agreement. But at any rate, Section 6.4 of the merger contract is entitled Access to Information Confidentiality. This is the clause that Musk says Twitter breached, which states, quote, "Upon reasonable notice, the company shall cause each of its subsidiaries to afford to the representatives of parent reasonable access at parent's sole cost and expense in a manner not disruptive in any material respect to the operations of the business of the company and its subsidiaries, to the properties, books, and records of the company and its subsidiaries, and shall cause each of its subsidiaries to furnish promptly to representatives all information concerning the business, properties, and personnel of the company and its subsidiaries as may reasonably be requested in writing in each case for any reasonable business purpose related to the consummation of the transactions contemplated by this agreement." Now, that is lawyer speak for Twitter must provide Musk with company information. And there are all sorts of caveats. It must be related to a business purpose. query whether Musk's requests are related to a business purpose or to screw over the business. It's hard to say. But Musk's legal team has said that, quote, Twitter has not complied with its contractual obligations under Section 6.4. Quote, for nearly 2 months, Mr. Musk has sought the data information necessary to make an independent assessment of the prevalence of fake or spam accounts on Twitter's platform. This information is fundamental to Twitter's business and financial performance and is necessary to consummate the transactions contemplated by the merger agreement because it is needed to ensure Twitter's satisfaction of the conditions to closing, to facilitate Mr. Musk's financing and financial planning for the transaction, and to engage in transaction planning for the business. So according to Musk's lawyers, Twitter breached its contractual obligations to close the deal. The centerpiece of the letter is that Twitter misrepresented the number of bots and refused to give Musk information that would identify the true number of bots on the platform. Though the lawyers couched it very carefully, quote, preliminary analysis by Mr. Musk's advisors of the information provided by Twitter to date causes Mr. Musk to strongly believe that the proportion of false and spam accounts included in the reported MDAU count is wildly higher than 5%. Now, that is not a factual claim about anything except what Elon Musk personally believes, which is a very sneaky way of avoiding an actual factual claim that could subject the lawyers to a little bit more scrutiny and the Musk in general to more liability. But let's hear about it from the man himself. Elon went on a podcast to explain that Twitter has so many bots that it makes Twitter a totally different company than the one he thought he was buying. Quote,
if they in fact have been vociferously claiming less than 5% of fake or spam accounts, but in fact it is 4 or 5 times that number, or perhaps 10 times that number, this is a big deal. It's not this. It's sort of like if you said, okay, I agree to buy your house. You say the house has less than 5% termites. That's an acceptable number. But if it turns out it is 90% termites, that's not okay. It's not the same house.
Now, if Twitter is 90% bots, then Elon Musk might be correct for reasons that we'll discuss in a moment. But is Twitter 90% bots? Probably not. But let's talk about Twitter's obligations. Twitter responded to Musk by giving him information about how it estimates the number of fake accounts. There's a long Twitter thread by the Twitter CEO that explains where the calculations came from. He said the 5% estimate is based on, quote, multiple human reviews in replicate of thousands of accounts that are sampled at random, consistently over time from accounts we count as MDAUs. Now, Twitter claims that its human review process uses both public and private data, like IP addresses, geolocation, and other factors to make a determination about whether an account belongs to a real person. Musk infamously responded to this thread with a simple poop emoji because that is the level of discourse that we face here. But Twitter eventually caved to Musk's demand for more information by giving him information about every single tweet in the Twitter universe. This has been referred to as the Firehose API, a stream of every tweet that's been sent. This dataset includes records of user tweets, the devices those users tweeted from, and real-time API data. And despite receiving this information, Musk says that he couldn't perform the analysis he wanted to, which may not be Twitter's problem. But his lawyers identified 5 more categories of stuff that they wanted related to user accounts. But the bottom line here is that Twitter probably gave Musk all the data he could reasonably be entitled to, and the contract probably doesn't require more of that. But there is another wrinkle here that deserves discussion, because even if Twitter underestimated the number of bots on the platform, Musk still doesn't have the legal right to cancel the agreement, because not all misrepresentations give Musk the right to back out. Now, in a normal contract, a material misrepresentation could absolutely give rise to canceling or terminating a contract. But this is a different kind of contract because people don't like to enter into these merger agreements and then have the possibility of backing out. And this contract would only be breached if the misrepresentations had a, quote, material adverse effect. Now, the phrase material adverse effect is a term of art used in mergers and acquisitions law. It's usually defined in the contract in a very long paragraph, and here the language has been interpreted several times by Delaware courts. We'll talk more about why why Delaware later on, because that's the whole thing in and of itself. But in Delaware, there is a high standard for showing a material adverse effect. The burden of proof is usually on the buyer. Usually material adverse effect is invoked when the target company starts having significant performance problems. But even if a company's performance is in decline and is dramatic, Delaware courts generally say that the time period needs to be measured in years, not just a few bad months. And as far as I can tell, Delaware courts had never found a misrepresentation to give rise to a material adverse effect until 2018 in a case called Acorn versus Fresenius Kabi AG. The Delaware court summarized the buyer's burden of proof. Quote, "A buyer faces a heavy burden when it attempts to invoke a material adverse effect clause in order to avoid its obligations to close. A short-term hiccup in earnings should not suffice. Rather, the material adverse effect should be material when viewed from the longer-term perspective of a reasonable acquirer. In the absence of evidence to the contrary, a corporate acquirer may be assumed to be purchasing the target as part of a long-term strategy. The important consideration, therefore, is whether there has been an adverse change in the target's business that is consequential to the company's long-term earnings power over a commercially reasonable period, which one would expect to be measured in years rather than months." The buyer in Acorn was able to demonstrate that the magnitude of the change in performance was material, and this poor performance lasted for over a year. This precedent probably isn't very helpful to Musk's claim that spam accounts mean that Twitter is dramatically overstating its performance in ways that could impact Twitter's profitability down the line. In fact, one could argue that if there are more bots than they know of, then its profitability can only go up even further, because he'll get rid of the bots and make it even more profitable per user. And this is especially true since Musk said he wanted to acquire Twitter to improve the product by eliminating the bots. The SEC filings include voicemails by Musk where he presses Twitter to get the deal done quickly so he can fix the spam accounts and make the company more profitable. Musk then sent a voice message saying, quote, "If the deal doesn't work, given that I don't have confidence in management, nor do I believe I can drive the necessary change in the public market, I would need to reconsider my position as a shareholder. This is not a threat, it's simply not a good investment without the changes that need to be made." So even though Musk was at the time the company's top shareholder, he didn't think the stock was a good investment unless changes were made. He then offered Twitter a share price that was significantly above its value. In other words, Elon Musk made it clear from the outset that his interest in Twitter had nothing to do with its current profitability. And he knew that there were too many bots. He said he wanted to buy Twitter to prove a point about free speech, and he said he wanted to make it a better product by authenticating users, eliminating spam, and adding an edit button. So to sum it up, it looks like Twitter has a pretty good argument that they gave Musk all the information that he needed and was entitled to. And further, Twitter can certainly argue that number one, the bot numbers aren't wrong, but even if they were, it's still not a material adverse effect. If the bot numbers are 7% instead of 5%, that's probably not material. Though it's also probably important to note that one reason that Musk and his lawyers have couched this as a failure to provide info instead of focusing on claims of misrepresentation is that the misrepresentations are covered by the material adverse effect standard, whereas the obligations of the company found in the covenants are generally considered material. So if they breached their obligations under the covenants, they have a better chance of getting out of the deal itself. Additionally, Musk's lawyers also claim that Twitter failed to run their business in the ordinary course of business by firing 2 key employees and losing others in violation of Section 6.1 of the merger agreement. That section of the contract requires Twitter to seek and obtain consent before deviating from its obligations to conduct its business in the ordinary course and preserve substantially intact the material components of its current business organization. And this is a very common term you see in these kinds of agreements. The reason is obvious. When you're buying a company, you want to make sure that that company continues in more or less the same vein than it started, and it doesn't completely change their business while you're in the process of buying it. And here, Twitter fired its revenue product lead and the general manager of consumer and other employees twit, possibly because Elon Musk was buying the company. So Musk said that he objected to Twitter firing many talent acquisition employees and that he doesn't like Twitter's hiring freeze. Quote, "The company has not received parents' consent for changes in the conduct of its business, including for the specific changes listed above. The company's actions therefore constitute a material breach of Section 6.1 of the merger agreement." Now, it is very rare for deals to fall apart over these kinds of obligations. Number one, Twitter legally can't force anyone to stay, not since the 13th Amendment was passed. And additionally, sometimes as a company, you need to be able to terminate people. That happens in the regular course of business. So we'll see if there's any hay here, but it seems unlikely. So let's talk about what's going to happen in the ensuing litigation. Nothing is certain in litigation, but based on the facts of this case, in terms of the legal arguments, I'd much rather be Twitter than Elon in this particular situation. Now, normally when you're talking about a breach of contract and contract damages, you're talking about expectation damages. The party that didn't breach is entitled to be where they expected to be after the contract was consummated. And you measure that by taking, in this case, the promised price, subtracting the current price of the company, and the delta is the amount that would be necessary to compensate you for where you expected to be. But here, the parties negotiated a bilateral $1 billion termination penalty. They considered that Twitter might get a better offer and might want to cancel this deal so they could go with the better offer. And they also considered that Musk might just, Musk everything up. But here, this termination provision is functioning like a liquidated damages provision. It sets the damages at $1 billion. Now, I suspect that if Elon Musk could get out of this deal by just paying $1 billion and walking away, he would probably take that deal and just walk away. But here's where things get really, really sticky, because Section 9.9b of the merger agreement gives Twitter the right to sue Musk for specific performance. Now, that is a legal term of art, but that basically means that Twitter can sue Musk and it can seek an injunction from the court forcing Musk to close the deal. Now, that is particularly complicated here because we are talking about a deal worth tens of billions of dollars. And it's also complicated because the deal requires outside financing from several banks. But the way that those agreements are written, the banks don't have a whole lot of outs here. Now, in law school, they teach students that specific performance is very rare, and it is. Courts generally aren't in the habit of forcing you to do something that you don't want. See, for example, the 13th Amendment. But it most often happens with real estate because it's thought that, at least legally, each piece of real estate is a unique thing that can't be compensated purely by money. But when you're dealing with contracts, courts would much rather make people pay money and go their separate ways. However, it happens more frequently in the context of mergers and acquisitions. Delaware courts have been known to order specific performance in just such a situation as this. Although it's more common for buyers to try and force specific performance, Delaware courts agree that sellers in the M&A context also have the right to force the sale to completion. So this is what happened when a company called IBP, the nation's top beef distributor, entered into a merger agreement with Tyson Foods, the nation's leading chicken distributor. Both companies performed poorly after the merger agreement was announced, and Tyson's had buyer's remorse. It tried to terminate the agreement, but IBP sued for specific performance. And in addressing whether a seller has the right to sue for specific performance, the court found no, quote, compelling reason why sellers in mergers and acquisitions transactions should have less of a right to demand specific performance than buyers. So the court concluded that Tyson had to go through with the purchase. The court said that even figuring out the right measure of cash damages would be too hard since the amount was presumably huge. The court said that specific performance was doable since during trial, Tyson's admitted that it just wanted a lower price and that the acquisition was still a good strategy for the company. The court also said that the shareholders would be better served on the whole by a specific performance remedy rather than a large damages award that did nothing but cost Tyson a large amount of money. And now I need to explain some trivia about the Delaware Courts of Chancery, where this case is going to end up. If you've been paying attention to litigation, you often hear people say it'll take years to resolve anything, and that's usually the case. That is not the case in the Delaware Chancery Courts. The Delaware Chancery Courts are basically business courts on steroids. They handle mergers and acquisitions for breakfast, and Delaware made a name for itself by being the most business-friendly state in the country. And the Delaware Chancery Courts have a specific expertise in dealing with these enormous business disputes. And they are fast. This could end up being resolved in months rather than years. And while the numbers are very high, the dollar amounts are very high, this is not a particularly complex case. In fact, Elon Musk is incredibly online, so many of the statements that he has made are public and will absolutely be used against him. So we'll probably have an answer to this question pretty quickly. And at base, the litigation outcomes are pretty stark. $1 billion in damages or force Musk to pay $44 billion to acquire a company he doesn't want. Now, in reality, depending on how litigation goes, I'm sure all of the parties will probably negotiate something in between. Maybe a bigger fee that lets Elon walk away, or maybe a lower price and he consummates the deal. It's entirely possible that everything was just posturing for him to get a better deal in the long term. Or maybe Elon never wanted Twitter in the first place. Who knows? But the important thing is that lawyers are going to get paid. And speaking of which, there is the breaking news that Twitter has indeed sued Elon Musk for 1 count of breach of contract. The company asked the Delaware Court of Chancery to enjoin Musk from further breaches of contract, to compel him to fulfill his legal obligations, and to compel consummation of the merger upon satisfaction of a few of the outstanding conditions. Now, maybe it's just me, but I find this particular complaint to be a pretty hilarious document. You can effectively put whatever you want into a complaint. It's your opportunity to tell your side of the story, and Twitter is doing just that. But it also just savages Elon Musk using his own statements and fills in quite a bit of the story. And it covers exactly what you would expect, that Musk is in material breach of the merger agreement. Twitter alleges that Musk didn't uphold his obligations, including financing, public disparagement of the company, and misuses information in the whole, backing out of the deal thing. But it also includes interesting tidbits like Musk didn't even read the information and reports that Twitter gave him, even though he's complaining about not having enough information. And Twitter alleges that he can't avail himself of the $1 billion termination fee and must specifically perform. He must consummate the deal for $44 billion. But given that this is Elon Musk, this is only the beginning of the craziness, and you'll be able to read all about the future antics in today's sponsor, Morning Brew, because that is my favorite way to catch up with pop culture and the news. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm thrilled to tell you why, because if you didn't know, Morning Brew is a daily newsletter delivered Monday through Sunday. It gets you up to speed on business, finance, tech, and law in just 5 minutes. And it provides a fantastic quick survey of the most important issues while being witty, irreverent, and informative. It's really, really funny. And did I mention it's completely free? This week I learned all about the James Webb Space Telescope, the continuing destruction of my stock portfolio, and the continuing destruction of the Texas power grid, which apparently doesn't work in the winter or in the summer now. Morning Brew is basically exactly the mix of news that I'm actually interested in, and stuff I didn't even know that I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every single day. So, Legal Eagles, this one is a complete no-brainer. Morning Brew is completely free, and it takes less than 15 seconds to subscribe. Just click on the link that's on screen right now or in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after you sign up, you should click on this playlist for more Legal Eagle, or I'll see you in court.